Okay, so yes, so we continue now with the topic on the judicial culture and gender balanced case law. Actually, we continue along the lines of Professor Krstić's presentation today, her lecture today, and along the line of other lectures that you had opportunity to hear for these past 3 days. More concretely, when we spoke of the gender perspective in human rights, when we spoke of the need to look at the human rights from the gender perspective and through the lenses of the gender equality, we insisted on the importance of actually understanding that human rights as they were created, as they were envisioned, since at least since the late 18th century, were actually dominated by the male concept and understanding of the world. And therefore, we have a need, if we want to achieve gender equality in the sense of reality, in the sense of social reality, we have a need to actually take an approach to human rights which is more receptive to gender equality. So to try to understand the key concepts from the gender perspective. And our today's overall topic, which is the feminist judgments, is actually exactly about the need to try to look through the existing legislation in a way which is more receptive and more adaptable to the gender equality. Now, the mere possibility to look at the law, at the same legal norms in different ways, comes from the very fact, which was already addressed by Professor Krstić, that law is actually, the language that we use in law is essentially indeterminate. So the language that we use is a matter of social convention, in as much as the core concepts that we will discuss today, and those are cultural, religion, and gender. They're all social constructs. And when we speak of the language as being indeterminate, we don't imply that the language that you use doesn't have sense. We only mean that that language has a sense which is typical for that culture. So the culture has different meanings. The notion of culture has different meanings. There are meanings which imply a very comprehensive concept of everything that we produce, actually. So both spiritual and materialistic values that we produce can be considered as culture. In that sense, we can speak of prehistoric culture, of Vinča culture in Serbia, of Gallo-Romanic culture, and so on and so forth. Or culture may be understood in a sense of spiritual development and spiritual creation. Now, culture that we use in the context of feminist judgments and in context of gender equality is a cultural system of norms, culture as customary ways of behavior, the patterns of behavior that we actually embrace and that we apply. Now, culture may concern different ways and walks of life. It may also concern different professions. And hence we speak also of judicial culture, and that is the way judges usually behave, the way the judges usually interpret the law and apply the law. And we see that the way the judges interpret and apply the law actually reflects the wider culture they come from. So culture is a macro concept, as compared to religion, which is a micro concept. But culture can also be considered in terms of a dominant and minority cultures. So very, very often certain professions which can be considered as minority cultures are actually under the strong influence of the dominant culture. And religion is an integral part of culture. So religion is an integral part of culture, and religion pretty much also influences the culture, the dominant culture and the more subordinate cultures. I won't talk so much about the gender at this moment. We have talked a lot these couple of days. I just want to point out that there is a strong interplay between culture, religion, and gender. And that our understandings of gender and our understandings of gender roles, the way we identify different genders, is pretty much actually predefined by the culture and religion that by the culture that we come from, or the religion which is dominant in the given context. And feminist theory has rightly pointed out that religious practices support the patriarchal gender relations, specifically subjection of women to male domination within the family. Now, culture may be seen as something which is embedded in us, something that we cannot change, something which defines us forever, and that would be the conservative approach to the understanding of culture. Whereas the liberal approach to the understanding of culture implies that we can actually change what we find inappropriate in the culture, in the dominant culture, or the subordinate cultures within the given society. And in that sense, there are different forms of socialization, and Professor Krstić actually invoked some of them. We spoke in the previous session of the education, and education indeed plays a very important role in the education. Nemanja mentioned media. Media also plays an extremely important role in the socialization. So in a process of interiorizing values which then determine our behavior, on the basis of which we conduct our behavior. There are, of course, other forms of socialization, family for sure, but also very important institutions. And we mentioned also that in 2 days ago, such as exactly religious communities, religious institutions, political parties, and so on and so forth. Now, the legal education plays a especially important role in this respect, because it is through legal education. Professor Krstić posed that question: why the judges are considered, and why do they very often behave in a conservative manner? It is because also of the way the faculty curricula are established. And unfortunately, faculty curricula in our country and elsewhere do not always correspond to the realities, and when I say realities, I don't only mean social realities, I mean realities within the judiciary and how the judiciary operates and how it should operate. So we don't actually always respond in an appropriate way to these particular needs of the society, and some of those needs are related to the gender equality. So we also at the law faculties, and this is exactly why we have this program at our faculty, and it's not only the case with our faculty, it is the case with many other faculties in Europe. These questions were disregarded and were actually entirely invisible until only a couple of decades ago. And they became important, and we started focusing ourselves on the gender equality and on the need to, as we say, mainstream gender equality. I hope you see, yeah. Okay, so So this is Feminist Judgements project. Rosemary Hunter, whom we had pleasure to host at our faculty a year or 2 years ago, is actually a leading scholar in this field. And the feminist, and Professor Krstić will talk more into details about this topic. The Feminist Judgements project is a let's say a current a strand of a feminist scholarship, which actually insists on the need, as I said, to reassess our legal system and to try to look at it from the perspective of women. Or what we also say, it strives to take the women's view into account. Rosemary Hunter says that Feminist Judgment project is premised on the proposition that in many cases the law is at least to some extent indeterminate, and the judges have considerable scope to make choices between competing interpretations of the law. In this process, a feminist consciousness or philosophy may legitimately come into play. The purpose of the Feminist Judgment project is to demonstrate how cases could have been written and decided differently. So we try to look at the judgments which are rendered, and we try to actually understand if there was a different way to draft those judgments and to see the concepts which were used. And now this is very important because it was raised in the discussion 2 days ago. While women judges may not necessarily make a difference, it is more reasonable to expect feminist judges to do so. So we also ask ourselves whether women's quota in political field, whether they make any changes in themselves, whether the presence of women in the judiciary changes anything, whether it makes any difference. I think that Mina mentioned in the discussion previously, and here we can see some of the points taken by the Feminist Judgment Project, why women do make differences in the adjudication process. They see the women might be taught to judge differently from their male counterparts because they bring a different experience of life to the task. So we have different experiences. We come from we have exactly different backgrounds. This doesn't mean that we should not take other backgrounds into account. This is very important because this was exactly a part of the discussion we had 2 days ago. The point is that the women's perspective, the women's point of view was heavily disregarded, and it has to be taken into account, in as much as other points of view should be taken into account, and this is why we speak of intersectionality when we speak of the discrimination as well. Because they are more likely to empathize with women litigants, because they might judge in a different voice, one which incorporates an ethic of care, or because they have greater commitments to principles of equality and gender justice. And here actually today I would like to ask all of us to embark upon that kind of project ourselves and to try to think ourselves what is wrong, if there is anything wrong, in the way judges decided a given case. Now, because of the relevance and of the interrelationship between culture, religion, and gender, I decided to take a case which is related exactly to some religious practices. So I'll give you a few information with respect to the background of these legal issues, and then I will ask you to reflect upon it and to tell to me what you think of it. Now, religious identity is something which is which makes the core of our personality, of those who are believers. In a famous judgment, Kokkinakis versus Greece, the European Court of Human Rights stated that, as enshrined in Article 9, freedom of religion is one of the most vital elements that go to make up the identity of believers and their conception of life. Furthermore, the court stated that pluralism, indissociable from a democratic society, which has been dearly won over the centuries, depends on it. So the respect for the religious freedom is something which is important for the identity of every believer, but it is also important for all of us. It makes our society pluralist. And the religious freedom implies also a freedom to manifest one's religion. So this is stated in the European Convention. It is reiterated by the European Court of Human Rights. Furthermore, the United Nations Committee on Civil and Political Rights, in its General Comment number 22, also stated that the observance and practice of religion may include the wearing of distinctive clothing or head coverings. So, to manifest one's religion can also be by wearing the clothing which is typical for that religion. And this is where the culture or customarily way of dressing up comes close to the religion, because very often these two practices are interwoven and we can't totally distinguish what is just a matter of culture and what is actually that religion prescribes and imposes. And I will also remind you that this is part of another project, of the Enlightenment project, that state has to stay neutral with regard to different religions. It should, as the court said in a Kokkinakis, it should enable the pluralism of different religions and different practices. Furthermore, in another landmark case, Leyla Şahin versus Turkey, the court stated that the state's role as the neutral and impartial organizer of the exercise of various religions. So the court emphasized the state's role as the neutral and impartial organizer of the exercise of various religions, as well as that the state's duty of neutrality and impartiality is incompatible with any power on the state's part to assess the ways in which those beliefs are exercised. Now, this is the general framework that we have. This is the framework which is. I'm aware of the fact that we also have participants in the school which are not only from Europe. I've taken the case law of the European Court of Human Rights as in order to give evidence to how judges defined these terms of the European Convention on Human Rights. But I would like to say as well that although there are differences with respect to for example, United Nations Committee on Civil and Political Rights, when it comes to these values which I've just stated, there is no distinction between the United Nations Committee and the European Court of Human Rights. Now, at the same time, we see actually in practice a clash between cultural religious equality on one side and gender equality arguments on the other side. And as I mentioned, feminist legal theory has rightly pointed out the challenges which come also from multiculturalism. So culture is very important. It defines us, but also culture is also a political argument. And it is used as a way to homogenize given population. And it can be used as an argument to homogenize the majoritarian, but also minority population within the given society. And when it comes to that type of homogenization, which leads to institutionalization, and church and religious communities are also a form of institutionalized culture and religion, the feminists have pointed out rightly that it is usually women and young people who bear the brunt of that homogenization. And here comes the problem of or there is no problem of wearing particular types of garments, or the problem of dress codes which are related to certain religions. Now, in theocratic Islamic states, a woman's dress code is mandatory and severely punishable for any breach. European states reacted differently to different types of veiling of faces. So there are actually 4 types of female coverings in Muslim communities. I will take, we will take here as a case for analysis burqa, which is the most interesting. But let us know that there is also hijab, which is a headscarf tied under the chin. There is also, so burqa is a full body covering, including a mesh over the face. Niqab is a full face veil, leaving an opening only for the eyes. And recently we had a case of burkini, a full body swimsuit, which was a reason for some administrative and police actions in some of the European countries. So we will take the case of burqa, a full body covering including a mesh over the face. I will give you just a few more facts, and then I will let you say what you think about it. I have mentioned the importance of religion in the even in nowadays world, and once again, religion and culture are extremely interwoven. For example, we speak of Judeo-Christian culture, and we put together both the notion of culture and religion in one concept. But religion, or freedom of religion, which includes freedom to wear, to practice and obey different dressing codes, is not absolute. So freedom of religion in that respect, as well as in other respects, may be limited. And I will here quote for you again, the provisions are pretty much same in the United Nations Covenant on Civil and Political Rights, so it applies to the whole world, to generalize. Freedom to manifest one's religion shall be subject to such limitations as it is necessary in a democratic society in the interests of public safety. So public safety can be one of the reasons. It can be also the protection of public order, health or morals, or for the protection of the rights and freedoms of others. So these are the grounds for the subjection, for the limitation of freedom to manifest one's religion. And I will take as a case for our discussion the prohibition of burqa in France, anti-burqa law. However, let me also tell you that France is not the only country at this stage. There has been a series of administrative and judicial cases on the wearing of the hijab in educational institutions and workplaces in France, Germany, Switzerland, and Turkey. And there have been also conflicts over wearing burqas and niqabs in public places and conflicts which are of political and even constitutional nature in France, Belgium, Italy, Norway, and Switzerland. In 2021, Switzerland introduced a ban in its constitution, a ban on wearing burqas. And then in the previous year, in 2022, it introduced a legislation implementing that constitutional provision. Now, I will focus on the French law, because this is where it started in the European discourse, and it led to a famous judgment of the European Court of Human Rights, which is SAS versus France. And we will take a look at how the judges, the European Court of Human Rights judges, considered this issue, but I will previously ask you to say what you think. Now, what was at stake in that case before the European Court of Human Rights was actually French law on the concealment of body and faces. And the law states, no one may in public places wear clothing that is designed to conceal the face. For the purposes of this provision, public places comprise the public highway and places open to the public or assigned to a public service. The prohibition provided shall not apply if the clothing is prescribed or authorized by primary or secondary legislation, if it is justified. Now look at the reasons for the justification of the exclusion of this provision. Justified for health or occupational reasons, or if it is worn in the context of sports, festivities, or artistic or traditional events. Any breach of the prohibition of laid down in the section 1 shall be punishable by a fine. And there was also an amendment to the criminal code, the French criminal code, which stated that any person who forces one or more other persons to conceal their face by threat, duress, coercion, abuse of authority or of office on account of their gender shall be liable to imprisonment for 1 year and a fine of 30,000 euros. Yes, Amila has replied, and she referred to Lauzzi. We will look later on. I would like to point out what I said also 2 days ago. If you have any questions or comments, you can always interrupt me, and I prefer that our dear students who follow us online take the floor and say what they would like to share with us, because I can't always follow the comments. Now, actually, I would like to ask you what you think. This is the law which is before you. A woman was condemned under this law because she was wearing a burqa while she was driving a car. And the case came before the European Court of Human Rights. What do you think of it? Do you think that these grounds, which are stipulated in the paragraph 2 of Article 9, which says freedom to manifest one's religion shall be subject only to such limitations as are prescribed by law. We see that there is a law. It's a clear law. There is no doubt what it imposes, and are necessary in a democratic society. Now, we will come to that point as well. But let us look now whether we can consider this prohibition to be justified in the interest of public safety, for the protection of public order, health, or morals, or for the protection of the rights and freedoms of others. So, do you see any ground? Because this is the position of the judges of the European Court of Human Rights. They have to dwell upon these provisions and to decide whether these provisions actually fit into these legitimate aims. If they fit into these legitimate aims, public safety, rights and public order, morals and health, rights and of others, then we will go further and we will discuss whether the third element of the analysis is satisfied, that is, whether it was necessary in a democratic society to ban the wearing of burqas. I remind you, it's a religious freedom in question. So, Nemanja.
I will try with human dignity, meaning every person, not just physically but symbolically, must have a personality, meaning face. And if we cover in religious purpose, cover somebody's face, it's like we somehow cancel their identity and dignity.
Sorry, I mean, we don't have any board here to write these, unfortunately, yeah? No. Okay.
I'll stick to that.
No. I want us to all have those in front of us. These. Thank you. Okay, so one argument which Nemanja gave is human dignity. I would like you all to think about these arguments. And if I can precise, the dignity is, in your opinion, in question because wearing of burqa denies dignity of women.
Yes, but I would also.
Did I interpret you well?
I would keep away from religion. I would stay away from religion, talking simply politically and secularistically.
But you understand? Okay. You stick to the question of dignity, yeah?
Yes.
You say this is against female dignity.
Yes.
Okay.
Farnas.
Yes. Harness. Thank you for this input, Harnaz. May I just say that there are some parts of Quran where it is mentioned, and they are the question of interpretation and discussion. Nevertheless, it has entered into the practice, and it is considered by many communities, Muslim communities. There are also different strands of Islam, and in many Islamic communities, it is considered as obligatory, one type of veiling. So there are. I agree with you that the Islamic doctrine is not fully coherent in this respect. There are different understandings and interpretations, and one of them is that it is prescribed by Quran. Okay, but now also the face. So the question is now, how do we deal with it? And even if it is not in the Quran, this is considered by people who are religious that it binds them, that they are bound by it. So they have no choice. Okay, so we have a question of we have these doctrinal incoherences.
Tanasije, could you turn on the microphone closer to the board where you're writing?
Okay, I'll stay here next to
Hear
the.
you better.
Yes, I'll stay here. So there are some doctrinal incoherences when it comes to wearing burqa, and there is a question, I would say, of true freedom, yeah, of true choice to wear it. Or if it is a matter of coercion, yeah. Okay. Anyone else who would like to bring any other argument in this respect? Yes, can you just tell us your name? Ivanes.
So yes, I think also we should take into the consideration the proportionality of the measure and also its aim. I don't think it's necessary to restrict rights in this way, particularly because I think there are better suited measures to deal with this public security or danger, especially such restriction that is aimed specifically at women. So this could be an indirect discrimination against them. And also, I wanted to say something else, but now.
This is a very good point because you discussed this topic with Professor. You discussed this topic with Professor Krstić 2 days ago, which is the question of indirect discrimination, and you can see that this is a neutral norm. It doesn't actually mention religion at all. It doesn't mention. It doesn't mention any religion. So you can say, you can imagine, you can imply that it doesn't concern religion at all. It was not intended to suppress a certain type of dress code. And then there is a question whether, it actually intentionally targets, but in a not open, direct way, a particular religion as compared to other religions which are present and culturally very dominant in let's say French or European society. But sorry, Mila and Nemanja, I'll just have to go back to Ivana. Ivana, you think there is a legitimate aim because you went to the proportionality and you said that the problem is in the proportionality of the measure.
Well, and also in the actual aim of the measure, because I don't think it actually works. It's not effective. And it's not an effective measure to protect public safety, especially since the fines are also very high.
So you would allow, if I understand you, you would allow wearing of burqas at the airports and...
well, this says public places, not just airports. These are all public places.
Okay, but then it's a question of proportionality. If I understand you well, you implied that public safety may be a reason.
Yes, but I think there are other measures, not the prohibition of burqa, but some other measures that could be used to solve this problem.
Like finger identification?
Maybe. I'm not sure, I don't know them, so.
Okay, but I understand that you implied that the public safety may be used as an argument. Although this measure may be disproportionate, in the sense that in some public places, not everywhere. Okay. Mila and then Nemanja?
Professor, do you imply that wearing burqa, most of the women who are wearing...
Can I just ask you for a second? We have 2 more questions here in the room, and then I'll give you the floor, if you don't mind.
Yes, no problem.
Thank you.
So my question was regarding practical issues of wearing burqa. How well you can see with burqa? So if you
drive a car,
for example, and you cannot turn around easily, then it can be an issue of public safety. So I don't have an answer, but yeah, also Is it just for the eyes?
There
or
is burqa is with the mesh over the eyes, and niqab is without the mesh. So there are these two. There are different types of dress codes.
Disregards both.
Yeah, okay. So if you cannot see really well, then it can be an issue of banning.
It can be. Is that, according to you, Mila, the only context where the public safety comes into ground as a reason for banning burqa?
Well, Anna mentioned something. Do you want to say, or?
No, that's what was mentioned, identification.
Yeah, of the
So,
policeman.
Yeah.
Okay, so identification as
Yeah.
well. This comes under the ground of public safety.
Yeah.
Identification or the risks of having car accidents or other similar situations. So there are some situations where it is simply unthinkable to have burqa. Nemanja?
Well, wearing burqa seems like being enslaved. It is obviously against the European Convention of Human Rights to be in any form a slave. And also, if I'm correct, burqa, the function of burqa is to stop any chance of communication with other people. So let's say another ground could be a violation of freedom of speech.
Okay, violation of communication with others. Okay, good. Anyone from the online side who would like to have a floor?
Yes,
Yes.
I would like to. Yes. Wearing burqa doesn't imply that most of the crimes which are done either in public places is done by the persons who are wearing burqa. And maybe the aim is to have identification, but it goes against a person's right to choice, right to have the way they want to live their life. And in India, there is a long debate going on in the state of Kerala. Some women wearing burqa were stopped from giving examination in the classrooms. They were not allowed to enter the classroom. Now, all the women wearing burqa, they are on the streets, raising their voice in the Supreme Court of India to allow them to wear burqa. So this is again an individual aspect of the way they want to live their life. So I think a lot of freedoms are in conflict, and which freedom have more weightage, public safety or individual autonomy? So that is a big question to decide.
Okay, so you have raised rightly the conflict between the public safety and individual autonomy. And you raise, actually, you take the position of those women who wear the burqas, and would you say that they are doing it voluntarily? Or
Yes, they are doing voluntarily, and now they are on the streets in India raising their voice that they should be allowed to wear burqa in school and other places. So
Okay.
we have two segments of people who are doing voluntarily and who are being forced, like in Iran. So different positions.
Okay, thank you. Any more questions or comments? Yes, Harnaz?
When I also said there is no such case in Islamic rule, I wanted to say this. It's the same. It seems covering face existed before Islam even. And now in some communities like Saudi Arabia, they have the freedom of wearing. Even in recent years, covering head is not obligatory anymore. But still, they are also using niqab. Yeah, I just wanted to say this. Yeah.
Yeah, thank you, Harnaz. Alexander?
Sorry. Okay, maybe we can take into account also the protection of rights and freedoms of others. Also, because I'm aware that I'm maybe on the third part of the test, but having in mind that we are talking about France, maybe we can take into account that by the French people wearing a burqa can be, how to say, something bad actually. Or because a lot of people in France can find that practice bad for that woman. I can connect that thing of protection of the rights and freedoms of others. Maybe I can connect with the dignity That is a question we raised first, I think, yes.
But, Alexander, is it a dignity for those who wear burqas or dignity for those who dislike burqas?
Well, I'm aware of that, but maybe I have arguments for the women who wear burqa, but I think when I say protection of freedoms and rights of others, I think of the majority of the people who can find wearing a burqa something bad. And they can find that bad for themselves, but also for that woman who wear burqa also. I think that we can make actually a connection between that.
Okay. Please keep that thought in mind. So this corresponds to a concept which...
I'm sorry, you forgot your microphone again. Sorry?
So, yeah, sorry. So this corresponds to a concept which was raised in the discussion, not among us, but in France and elsewhere, and that is the concept of living together. So there is something what some French would consider as their constitutional principle of living together, vouloir vivre ensemble, so we want to live together, and it presupposes we can see each other, and therefore you have to open up yourself.
Can I just add one thing? If we live in a democratic society, that means that we need to respect all the cultures, but it also needs, well, that is not my argument, just to clarify, but I'm aware of the problem so in France. But there is a strong argument, I think, that even if we need to respect all the cultures, we also need to respect the will of the majority. And living in a democratic society doesn't mean only that we need to protect all the cultures, but also that we need to accept the values of the majority.
Okay,
and that is a value, for example, of living together, living in a democratic, open society.
Okay, and what about the pluralism? Where does the pluralism come into fora if...
Well, I'm aware that, women can wear a burqa. Okay, that is a part of the pluralism. But on the other side, if you have a society, like a French society, I don't want to say that argument because that is for the third part of the test. But we need to have in mind that we are talking about the state that has a strong tradition of laïcité.
Yes.
The strong tradition of separation of religion and the civil society.
Okay. Thank you, Alexander. I started the discussion with you, but I could have also, and we'll continue discussing with the others as well. Mina?
It's not me, I just wanted to say two people have politely raised their hands online a while ago, Larissa and Amila, so maybe we could hear them now.
Thank you, Nina. Mina, if you don't mind, we'll let people
Of course.
Yeah, okay, so can I hear you folks who are online?
Hello, I'm with my little girl, and maybe you can hear something which is not a part of this discussion.
It's okay. We
I think that we heard here a lot of Islamophobic sentences and many stereotypes, and that is the product of our European identities, because we need to be more open-minded and respect all religions and all cultures. Also, this legislation in France is product of laicism. From the other side, we have, for example, in common law, legal cultures, concept of multiculturalization, and in America, in Canada, in New Zealand, you can wear niqab, you can wear hijab, you can be a judge with hijab. For example, we have in High Court in the United States of America, women with hijab. And maybe we need to be more American than from Balkan.
Yeah.
Thank you very much.
Okay. Thank you, Amelia, for your intervention. Who else would like to speak from the online side? Okay, Mina.
Well, yes, maybe I wanted to take into account minority rights. Maybe Professor Krstić knows more about that. But we had a discussion with Professor Miodrag about a sense of belonging somewhere. And I am well aware that there is no definition of what minorities are on an international level. But I think that France, if we focus on them, are very discriminatory towards minorities because they consider that they don't have minorities, ergo they don't need to protect them, which is fair because there is no such definition. So, and every state has the right to make their own definition. So France says that according to their definition there is no minorities, and I do understand that, but I think that when we talk about minorities we have to take into account that maybe if they're living in that state and if they are citizens, they need to feel like they belong there. So banning them or saying that majority of French people are going to be disturbed by Muslims or them wearing their traditional attire or whatnot, that only can cause harm to every other minority because it sends the wrong message. We don't respect Muslims. How are you going to respect other minorities and their uniqueness?
Thank you, Mina. I understand your argument, but just to point it out, here we don't even speak of minority rights. These are individualistic, universal, Declaration of Human Rights also stipulates this right. So this is not a minority right; it's an individualistic right, which is recognized to to everyone. So without a distinction of citizenship, let's say, or any other qualification. In France and everywhere else in Europe. So this is a document which binds France, the European Convention on Human Rights, in as much as it binds every other country. So it's not even about minority rights. Okay, Nemanja, did you want to add something?
Yes, thank you. I would like to expand the term dignity with transpersonal dignity in the way of Gustav Radbruch's thought, because all I see here is a fight between individual and collectivistic against women, Muslim women and French society. So why transpersonal? Because it's above religion and above a certain period of time. And as we saw on a picture, we have 4 types. So for me, maybe I'm wrong, but hijab looks like a compromise, because we can see somebody's identity, personality, and face, but also parts of body are hidden. And as much as we bring some more clothes on, it's going in some extremic direction.
Okay, thank you. I will come back to you. Your and other arguments. Yes, your name, please.
My name is Jovana. I would like to address another question. I think that wearing burqa can open a comprehensive problem in labor law. I'm dealing with labor law, and wearing burqa at the workplace. I think that there was a case, I cannot recall the name, where judge accept that this employee cannot take burqa, and that can be justified by the economic interest of employer, I think.
Thank you, Jovana. Yes, there are many contexts in where we can look into more details this question. But let us not forget that this is a blank prohibition in all public places. So we don't speak of labor law contexts. We don't speak of medical people working in the health institutions, or we don't speak here about teachers. So we don't speak of the educational system. We speak of people that we can come across in the street and who are sitting in the park, and we come with the idea to actually ban their dress code, the dress they're wearing. So these are the arguments that we heard. Is there any more? Anyone else who would like to intervene and say something on this topic? Sure, Anna.
So we are talking about public safety right here, about the proportionality, and I think that for this we have to take into account the situation in France, saying that they have a problem with terrorism and they're trying to. Okay, so if we take into account the situation, we may say that this would also can be justified on the safety reason. But what I would like to say is that during COVID-19, for example, we had many pictures of people wearing masks and hats because it was winter, and it was not forbidden to wear mask and a hat. While it was completely forbidden to wear a burqa or any other different type of this clothing. So I would say that here we see differences in treatment, and that's why when I hear about the public safety, I would say that maybe this would not be so justified.
Thank you, Anna. Thank you for these 2 points. I would like to also remind you that at that moment when the ban took place, there was no terrorism in view in France. Okay, I mean, maybe it was a part of the Islamophobia which came out as a reaction to the attack on Twin Towers in New York in 2001. And there were 2 more terrorist attacks at that time, actually quite earlier than this time, 2010 in France. It was in 2004 and 2005 in the UK and Spain, in London and Madrid. So the terrorist attacks took place afterwards. And I don't know, also I have to say, I don't know any case where anyone wearing burqa committed any terrorist attack. But this is very good point that you made. I will reuse your argument. Do we have some time to wrap up? Yeah.
Interesting discussion.
We can take the discussion time from the end,
But it's good, it's also part of the discussion. So we'll not have a formal part for discussion. We're discussing all the time. So just
I think that basically there are 3 arguments that we could hear when it comes to the legitimate aim. One is the question of dignity, looking from the perspective of women who wear burqa. And it was argued that burqa is contrary to their dignity because it prevents them from establishing relationship with others. It doesn't put them on an equal footing with the others. Are we okay here that we can raise the argument of gender equality in this context? Nevanja?
Yes, obviously we are.
Okay. So there is this argument of dignity / gender equality on one side. There is the argument of public safety. And we heard that there are many instances, we agreed more or less that it is legitimate that when safety is at issue, in some concrete cases like going to the banks or going to the airports, and where it is important to identify people at the exams as well, and so on and so forth, or in relationship with children, the educators, that it is actually needed to have that kind of restriction. And we had the argument of the feelings of others. The living together concept, which is a French concept, a part of their understanding also of laïcité. So these are the 3 arguments that we heard. And we will discuss about those arguments. I'll come back to them, but I will read to you what the European Court of Human Rights took into account.
Okay, yes, before we went to this, I wanted to ask why would we feel that it is against the human dignity if a woman wants to wear this, and now I understand. What I wanted to say is also that I think that if we started from the point that every woman does not want to wear this, we are trying to annul another culture. Because if there are some people who are Christians and want to wear a cross, we do not think that it is because they're forced or whatever. And I do not want to deny that many women in Muslim world are affected by this, and they do not have a choice they do not have a freedom of choice to decide if they want to wear it or not. But for those who do want to wear it, I do not see a reason why we would start from the fact that they are forced, and I think that this again leads to Islamophobic thinking or Western thinking, Western perspective of Muslim religion.
Thank you, Anna. I do think that we have this issue at question. How paternalizing are we actually when we tell to these women that this is contrary to their dignity? Aren't we actually denying their dignity by telling them what is good or what is bad for them? The European Court of Human Rights took the question of equality between men and women in this context by saying if they're forced, this is obviously against their dignity, if they're forced. But what if they're not forced? How do we deal with that? So that is the first question. The second question of public safety, we'll come back to it because it's something which is indeed relevant. But living together concept, which the French government raised as an argument and which the court took so seriously into account, is nowhere stated in the convention in Article 8 and 10, paragraphs 2. Article 8 stipulates the right to a private life, and this can considered in some well, I mean, okay, I won't go there at this stage, but let us stick to Article 9. Article 9, paragraph 2 stipulates these conditions for the limitation of the right to freedom of manifestation of religion. And we do see that there is protection of the rights and freedoms of others. We don't see living together concept. So basically, we come into a situation to restrict one fundamental freedom, freedom of religion, to manifest one's religion by wearing certain dresses because of the feelings of others. What happened to the pluralism which defines European societies? When you can raise that argument to trump feelings of others because what they're hurt by seeing. And by the way, the European Court of Human Rights had a clear idea of how many women in France at that stage wore burqa. In whole France, metropolitan plus other territories, 1,900. Argument which was raised by the French Parliament in the discussion when it was adopted. So the court took a very limited understanding of the importance of equality by not dwelling and going into these instances when is a woman actually oppressed to wear it. The court didn't go into that side. The court only said if she's not oppressed, we cannot raise the argument of equality. But what if she is oppressed? Isn't that a question of dignity then? Isn't it actually a question of dignity if a woman is oppressed? And Anna, you made the right point about by giving the examples of how we were dressed up under COVID period. So we saw that, I mean, we all know that when we do some winter sports, we're all dressed up and we don't see each other at all. We even put glasses, winter glasses. We also put glasses during summer. So we don't actually see other people's eyes. And we don't consider that rude in most situations, and we communicate equally well. So eyes are sometimes more important as a form of communication, as being the source of the soul, than necessarily other parts of the bodies like mouth and nose. And there are other ways also to communicate. But the European Court of Human Rights didn't take these things into account. The court didn't take these things into account. It just said that if it is, if the woman is oppressed, it is not okay. But he didn't go into the consideration why and when we can consider the woman is not oppressed. And it considered that living together is okay as an argument, although we do understand that there are many, many different ways we can communicate with each other. And these are the arguments which raised Martha Nussbaum, the famous female philosopher, who actually defended refuted all of these arguments. She actually gave examples of many other cases where women are objectified rather than wearing burqas and being considered as some consider as being imprisoned by wearing burqas. Yes, they're imprisoned if they don't want it. So, and many other arguments that we also hear in the discussion. So the point is that we have to take into account both the freedom of religion, what it is for many women, but also to take into account that religions may be oppressive, and that we need to actually dwell upon the criteria under which to dwell upon better upon the criteria under which banning the burqa should be banned. Now, another problem is that a public safety argument, which I think no one in general disputes in principle, we have seen that it's a blanket ban. So it is not allowed anywhere except in private premises, except in the religious institutions. The question is, how come that there is such a blanket ban, and that we didn't consider even a slightest possibility of that this provision is actually discriminatory, indirectly discriminatory. In order to come out of it, the European Court of Human Rights resorted to an argument which it always does when it comes to sensitive issues. It accorded a very wide margin of appreciation to the member state and said this is a matter of high importance for the given state. But the problem with the court's approach is that the margin of appreciation, a wide margin of appreciation, is accorded when there is a consensus on the opposite side among other European states. And the court itself admitted that at that time only 2 countries had this kind of provision, which is Belgium and France. So not only that it accepted legitimate aims, including public safety, but it didn't consider the possibility that maybe public safety is not relevant everywhere. The time has elapsed. I wanted to tell to you that actually, to give you an example of a case where we can think of redrafting a judgment, taking women's perspective into view, and here taking a perspective of women who are religious. Because public safety argument, I think no one disputes, provided that it is restricted to the places where it is important. So what the court didn't take into account is that the concept of public place is is also multifarious. There are different types of public spaces. So parks and beaches and forests are also public spaces, but they're not of the same importance as school teachers. So we should distinguish different types of public spaces and the relevance of them in the given context. That is one thing. Another thing, I think this is not the first time that we are dealing with the situations when someone raises the argument of its belief or its consciousness. We have a conscientious objection as well. We have people who have a right to be exempted from serving army when they have a conscientious objection to serving army, for example. Why wouldn't we apply this kind of procedure also to those women who would like to wear burqas in public places, while at the same time, just like the French law, criminal law stipulates that any person who forces one or more other person to conceal their face by threat, duress, coercion, abuse of authority or office is punishable. Let us think about those measures, because also when we exempt someone from serving army for the reason of the conscientious objection, we also conduct an interview with that person to see whether it's a case of true conscientious objector. So why wouldn't we use, among other measures, and many of them are offered by different forms of socialization, this procedure for those who would like to actually, for the reason of their belief, which make part of their identity, wear burqas, to be sure that it is voluntarily and that it is not a case of a cursive wearing of burqas. Oh, yes, please.
And thank you very much that you addressed this slide, because this is where my concerns arise when it comes to the question of freedom of choice and the minors. Generally, are we able to speak about the freedom of choice in minors, in the children? All children, most of them are raised and in the culture and religion their parents belong to. Very low percentage of children from
Larissa, can I just ask you to stay for 2 seconds until we solve the problem of sound in the room, because we didn't hear you anything. So I apologize to you. Can we hear you again?
Yeah.
Okay, it's better now. Thank you.
Do you hear me now?
Yes, we do. Please go on.
Okay, so my question is generally about this freedom of choice when it comes to minors and children. So how is that regulated in the human rights constitution? Because children are not given freedom of choice to religion or anything. They are coerced, or, I mean, how should I say? It's really difficult, and it's difficult to say, but I'm a secular person and I look from very different perspective. I raise my children and give them full freedom to decide whatever they like when they're, grown up. If they want to be religious, they will be. So, but this is really a huge, it's an issue. It's an issue of culture. I mean, you cannot annihilate one whole culture, because children are being born, bred, and acculturated into different religious backgrounds. So with this article that we're seeing now, and with this offense, which is committed against a minor, so may this thing with burqas be interpreted in a way that every girl as a minor that is practically she's imposed to wear burqa. I mean, it's not her choice. I'm really confused here. Ethically, I'm ethically confused. How are we able to talk about the freedom of choice in minors? I mean, that's my concern. Yeah.
Thank you, Larissa. It's a very good point. I'll give now the floor to Harnaz, and I'll come back to you.
Actually, before this question, I was thinking to mention it. It's like brainwashing. I was a little girl when my aunt was telling me, if you don't cover your hair and your body, you will go to hell and you will burn there. I mean, after that, I could choose to wear hijab, but it was like brainwashing. I mean, it was not this is what she mentioned also. I mean, I could grow up by that mentality and I start wearing hijab by my choice, but it was not a real choice. Yeah, actually, she's right. I confirm it. Yeah.
Yeah, I wanted also to add that because I was raised in a very, very, how should I say, radical Orthodox community. And nothing of that was my choice when I was a kid. And I was also intimidated by the forces of devil that will come upon me when I was a kid. And we can now address this as a human rights issue. We can address this fully. And yes, my choice was to obey church rites because I was heavily intimidated by that. And also, in this community, wearing veil in churches is mandatory in Christian churches. So these are my experiences, but once you have mentioned yours, I wanted to share mine. Yeah.
Thank you, Larissa. Thank you, Harnaz. Anyone else who would like to make a comment, point, question?
Yeah, we have always the other side. For example, I am from a very secular family, and I am the only religious, and I have a hijab, and also I finished my PhD. I'm senior assistant in Faculty of Law, and all this is a product of my own opinion, of my own choice, and because of that, I don't want that anyone said that you are a person, you are under force. This is a product of your family or of your religious community, and this is the reason why this topic really attacked me.
Yes, I want to say something like everyone has their own choice and ways of living, and there are certain things that we should not particularly control. Even the lawmakers and the state should refrain from doing such laws, because this is again body autonomy, and individual autonomy should be respected. If we say 1900 burqa people in France, so they are in minority. The number is less when we considered with whole population of France. In India, we have we are the first, the most populous country of the world. We have surpassed China, and we have 30% Muslim population, and all of them are allowed to wear burqa, and there is no state concern. Despite of continuous terrorist attack, no place has banned burqa.
Thank you very much, Singh. Okay, so thank you all for your inputs. I think that this question, which was raised by Larissa, and then the comments which followed, actually showed its importance. So thank you, Larissa, for raising it. There is no doubt that we set up in all societies different rules for the minors and for those who are majors. So I will remind you that one of the big fighters for women's rights and for freedom in general, John Stuart Mill, said that a principle of liberty does not apply to minors. So minors are not allowed to do anything they wish to do. So minors are under the control of the parents. So here comes the conflict, what is at fora, what is at question is a conflict actually between the rights of parents to educate children according to their religious and philosophical views, which is guaranteed by the European Convention as well, Article 2, Protocol 1 to the Convention. And at the same time, rights of children to be given opportunity to choose what is the best for them. But of course, since they don't know what is the best for them, it is either the parents who will decide or it is the society which will decide. And in most cases, the society leaves to parents to decide for their children. However, we had at the beginning of this presentation today, I mean at the lecture of Professor Krstić, the case of female genital mutilation. So we have practices which come from the religion and from customs and cultures which go contrary to the interests of the minors. And in order to be able to make free choices at the time when they can make those free choices, I think it is important to raise the minors in the spirit of equality between men and women so that they can make their informed choice, women for themselves and men for themselves, when it comes to religion and different ways of observing religion, whether they're gonna embrace one religion and whether they're gonna embrace the concrete form of observance of that religion. So I would resolve that issue by not allowing for these kind of practices, especially when it comes to burqas, but also for hijab, because it puts boys and girls at in a position of inequality, and it can be harmful for their further development and the choices they make in their life. So I would insist that society imposes these kind of regulations in these kind of instances, but not for those mature women who believe in the way in which they believe and they consider that this obliges them. Okay, thank you for... Yes, sure, Ivana.
Really sorry, just to interrupt here. First of all, Larissa said that the child doesn't have the right to religion, which is not right, because we also have here conflicting interests, and we have the convention, UN Convention, the rights of the child, which also stipulates and guarantees this right. So this convention also gave us some 4 guiding principles, and one was mentioned by Professor Marinković, which is the best interest of the child, and another one is participation, which also was mentioned in a way that children also needs to be heard. And now we return to what we discussed at the beginning of our class today, or in the middle of the class, when we said what are the measures, how we can achieve equality. And we named policy, education, media, so on and so forth. Parents are also members of this society, which means that awareness raising, education is really the most important step forward. For example, in Serbia now, and I think that this is really a question of high priority. What is the role of parents in educating and also treating their children? You know, and I'm pretty familiar that also other participants who are present at this school know that 3 weeks ago we had a bombing in one primary school. And what we have at the moment is that we have some parents which are opposing that their children return to this school, although children wants to go to school. And we have psychologists saying why it is in their best interest to return to school, and they want to go there. But parents, they disregard their opinion. So this is only one example of how the right of parents can be misused, and how by blinding and how interpreting by our own experience what's happening around us and around the world, we can really treat our children not in the way that we perform this best interest of the child principle. So I'm really happy that we opened that floor, because here we of course speak, when we say gender equality, not only about women and men, but also about boys and girls. And at the beginning of this class, we also mentioned 2 harmful practices which both affect children. So it's great that we will stop here and conclude here, but I'm pretty sure that this question will be open through the school until the end. So Tanasije, if I take the floor and now give you the mostly needed break, I see your faces and I'm pretty sure that also our participants online need it. So we will have a 15 minutes break. I think that you have coffee outside and water, and if you agree, because I see that we are all tired, and I think that this discussion was really inspiring, but also it took a lot of energy from all of us. I will propose that when we continue, we will finish the presentation on the international jurisprudence in relation to gender biases, and then this feminist project, which is also a short presentation just to give you an overview what was done, we will do tomorrow when we cover this legal clinic session, if you agree. Okay, so now 15 minutes break, and then please return that we can finish on time. Thank you so much.
Izvinite.